faithfully applied, the presidential elections must be held this year on the 11th of August 2026. And that is what the court has today affirmed as the position. IEBC had erroneously moved on the premise that a president is elected to serve for 5 years, for a 5-year term. That was their argument in court, and the court told them, just like we had told them before, that there is no 5-year term anywhere in the law provided to the president, members of parliament, or the governors. They only serve until the next date of the elections. Then the president becomes a temporary incumbent. Members serve as temporary until the next parliament is sworn in. So as we are today, the date as ascertained in our constitution and affirmed by the court, the next presidential elections in Kenya are to be held next week on Tuesday, 11th August 2026. The court has merely recognized the logistical and administrative challenges of having the elections next week on Tuesday, and has decided suamoto to suspend the effect to give IEBC time to organize its logistics and administrative components for the conduct of an election. I am also guided by the law, which says if an act is to be conducted on a specific date and it becomes impossible, administratively impossible, to conduct that act on that specific date, then the act must be done within the shortest time possible when it is possible to conduct that act. In this particular instance, the elections are to be held on the 11th of August 2026. But if, as the court has recognized, that it is impossible to conduct the elections next week on Tuesday, then IEBC has a duty to conduct the elections within the shortest time possible that is necessary to make the necessary logistics and administrative arrangements to conduct that elections. I am guided by the precedent that IEBC has shown, where when a vacancy has been declared for office of a member of parliament, IEBC, as per the constitution and as per their own administrative arrangements, have been able to conduct elections within 60 days from the date of declaration of a vacancy. We may admit they may not be ready by next week, Tuesday, but our presidential elections, as confirmed in the Maina Kiai case, are constituency-based elections. We want to hear why IEBC cannot instigate the constituency election officers, the returning officers, to conduct elections within 60 days from the 11th of August 2026. If there be any other logistical arrangements beyond 60 days, they should make a case to the people of Kenya that we need an extra 60 over and above the 60 in the Constitution. They should conduct those elections within 120 days. That is what the Kenyan people can take as permissible. Anything beyond that, in my view, is an usurpation of the sovereign will of the people. And the legitimacy and the term of office of William Ruto as president, exercising a donated sovereign power of the people, lapses on the 10th of August 2026, midnight. Beyond that, we are moving to the next phase of a temporary president. Is there any question to me before my party leader speaks? I'm now speaking as advocate in the matter. My party leader, Jimmy Wanjigi, will speak on any question on the political connotations in the case. Yes. If an appeal is preferred, we must take note. The court has found what the Constitution says, Article 2 of the Constitution, as read together Article 23 of the Constitution, does not permit you to suspend the Constitution. Going to the Court of Appeal does not give them an opportunity to suspend any provision of the Constitution. The Constitution, as breathed by the High Court, is that the elections, the elections are to be held on the 11th of August 2026. What we are now discussing, which they may have been asking the Court of Appeal, is if it is practical to hold the elections next week on Tuesday. And the High Court, in its wisdom, has already addressed that question. It has told IEBC that maybe you need some extra time to organize yourselves logistically to conduct the elections. So if they went to the Court of Appeal, it will be purely an academic exercise on the question of holding the elections next week on Tuesday. It will not be serving any legal purpose because the High Court has accommodated them and told them that we will not implement it from the 11th of August 2026, but have given you time to organize the elections. Our quest is now to tell the IEBC, having been told what the law is, do it within the shortest time possible, post the 11th of August 2026. Yes, Justice. As it is now, any decision IEBC will make as to the elections date cannot be a secret weapon to IEBC or to William Ruto. The date of elections remains 11th of August 2026, and for IEBC to call for the next election date, it must be now a consultative process that involves the people of Kenya, because it's now their sovereign will that is being suspended from the 11th of August 2026 to a new date. So the sovereign must render himself as to that new date in a manner that will facilitate him to donate his sovereignty in full compliance with the Constitution. The court has suggested a suspension of 1 year. As petitioners, will be asking the court that 1 year is 1 year too long. 1 year is too long for somebody to exercise a donated sovereign power beyond what will be permissible. William Ruto and any other presidential candidate must go back to the people and get a full mandate within the shortest time possible from the 11th of August 2026. Yes, Chris. In my view, Justice Mugure Thande recognized the Constitution and applied the law as it is, rightfully so. She only took cognizance of the logistical challenges that will be required or that IBC will have to surmount to hold the elections next week on 11th of August. So having so recognized, she decided to take the long route of suspending the implementation of the decision. But it is our case that the suspension cannot be for 1 year. The suspension, as per the law, should be that you conduct the elections within the shortest time possible to address the logistical and administrative challenges that are necessary to accord the people an opportunity to exercise their sovereign mandate.
Nothing else?
Thank you.
Mine will be very brief. This is a great day for the Constitution of Kenya, and we as Safina Party want to give a great thank you to the High Court that has upheld our Constitution, and to the excellent work of our Deputy Party Leader, Willis Otieno. He has been excellent in court. He came out and tried to educate Kenyans, civic education about it. The last 1 year, he sought even discussions with IEBC, who ignored him. And now today we have a constitutional victory. And this we must be very, very thankful of as Kenyans. Let me say, William Ruto, your time is up. On Tuesday, you become nothing more than a president that has been given mandate by a court because of logistical issues, nothing else. Your term is over as of Tuesday. You are now then just given a template by a court. Your term has not been extended. That means if we were to read the Constitution, Article 134 describes a temporary president for such a circumstance. The first vote should have been on Tuesday, the 11th. After the first vote, you become a temporary president. And there are various things you can and you cannot do. Article 134 is very clear. So do not pretend to us you can make any decisions on our behalf anymore. You cannot. You cannot pretend to have a national dialogue. You have no legitimacy, William Ruto. You cannot even fire a minister after that day. Appoint a new officer after that day. We shall challenge you. Your time is up, and it was up a long time ago. And you keep being reminded, you refuse to listen. This is a great day for Kenyans. Let us celebrate. Wakati sasa umefika ya Ruto kwenda nyumbani. Asanteni sana.